My name is Maria Serpa, chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing pharmacy law. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. As I facilitate this meeting, I will announce when we are accepting public comment. I advised the meeting moderator to allot 3 minutes to each individual providing comments. Throughout the meeting, at appropriate times, we will begin public comment for the individuals attending in person, followed by public comment by individuals attending via WebEx. This approach is necessary to facilitate this meeting. Before we get started, I'd like to ask staff moderating the meeting to provide general instructions on the process for providing public comment via WebEx. Moderator?
Thank you. This is Shelley Jones, and I'm your moderator for the day. Before we get started, I would like to remind board members and staff who are not speaking to mute their microphones to reduce background noise through the WebEx. There are members of the public in the audience and on WebEx today, and meeting minutes are being taken, so we do ask that members and staff identify themselves before speaking. For those members of the public joining us on WebEx, we will be using the WebEx question and answer feature and hand raise feature to facilitate public comment. When public comment is called for, I will open the Q&A feature. You will indicate in the text box that you would like to make a comment by typing the word comment, and then you will click send to send that through to myself. You can access that Q&A box by clicking on the Q&A icon that looks like a question mark inside of a square, typically at the bottom lower right portion of your screen. For those of you who are calling into today's meeting, you can utilize the hand raise feature to raise your hand, and you can do that by dialing *3. As Chair Serpa indicated, we will take public comment from those in HQ1 first, and then proceed to comments through WebEx. So we will be taking those comments in the orders that they are received. And with that, I will turn the floor back over to Chair Serpa.
Thank you. First of all, I'd like to begin by thanking the committee members for their travel and presence here in Sacramento for this in-person meeting. It's been a while since we've been in person, and welcome. Lots of traffic today, so I appreciate everyone being here. I would now like to take a roll call to establish a quorum. Renee Barker.
Licensee member present.
Indira Cameron Banks.
Public member present.
Just present.
Public member present.
Thank you. Sung Oh.
Licensee member present.
Jig Patel.
Licensee member present.
And I'm present. So a quorum has been established. Members, we have a number of presentations today. I ask everyone participating to be respectful of the work before the committee. We encourage participation by members of the public throughout the meeting at appropriate times. The committee requests that when comments are provided, they are done so in a professional manner consistent with how the committee conducts its business. Moving on to agenda item 2, which is public comment for items not on the agenda. I will now ask the moderator to open the line for individuals to provide an opportunity for public comment. You are not required to identify yourself, but may do so. I would like to remind everyone that the board cannot take action on these items except to decide whether to place an item on a future agenda. Members, following public comment for this agenda item, I will ask you if any of the items should be placed on a future agenda. As a reminder, this agenda item is not meant to be for discussion, rather an opportunity for members of the committee and members of the public to request consideration for an item for future placement on an agenda, at which time discussion may occur. We'll begin with public comment for people in Sacramento. Any public comment in the audience here? Okay, seeing none, moderator, we're ready for public comment via WebEx.
All right, this is the moderator. I have opened that Q&A panel. Again, if you'd like to make a comment, please click on that Q&A icon, type comment into the text box, and send that to our panelists. You can also dial *3 if you're a call-in user to raise your hand. We'll allow just a brief moment for people to submit requests if we have any. And I'm not seeing any requests at this time. Would you like me to close the panel?
Please do, thank you. We're moving on to item number 3, approval of the April 13th, 2023 committee meeting minutes. Members, attachment 1 includes a copy of the draft minutes from the April meeting. Do you have any questions or comments on the draft minutes? And I would also entertain a motion if you believe such is appropriate. Members, any comments or questions?
I can make a motion to approve.
Thank you.
I'll second that.
Thank you. With a motion and second on the floor, I'll now open for public comment on the April 13th draft minutes. We'll begin with public comment here in Sacramento. Any public comment in the audience? Seeing none, moderator, we're ready for public comment from individuals on WebEx.
All right, our Q&A panel is trying to open. Okay, it is open. Our Q&A panel is open. If anyone would like to comment on this motion, please click on that Q&A icon and submit the word comment. You may also raise your hand if you'd like to utilize that feature. Our call-in users can dial *3 to raise their hand. And not seeing any requests at this time. Would you like me to close the panel?
Please do, thank you. Members, if there are no additional comments, we'll go ahead and take a roll call vote. Okay. Renee Barker.
Yes.
Indira Cameron Banks.
Yes.
Sung Oh.
Yes.
Jig Patel.
Yes.
And the chair votes yes, motion passes. Thank you. We have several presentations today, and we're going to start with agenda item 4, which is presentation on the disciplinary case process by the Office of the Attorney General. Members, as a part of the actions undertaken by the board to meet its consumer protection mandate, the board may refer a completed investigation to the Office of the Attorney General in instances where the investigation identifies egregious violations that warrant removal or restriction of the license. A review of the annual statistics reveals that the board referred 259 matters to the Attorney General last fiscal year, which is about 8% of all closed investigations. The data also reveals that 218 disciplinary matters were closed with outcomes including 59 revocations, 74 licenses placed on probation, 67 licenses surrendered, and public reproval of 20 licenses. This morning, we'll receive a presentation from Christina Jarvis and Nicole Trauma, Deputy Attorneys General, who serve as liaisons to the board. Good morning, Christina and Nicole.
Good morning.
Good morning.
Thank you for your efforts to protect California consumers and for coming today. I give the floor to you.
Thank you very much. We have a PowerPoint that should be on the screen now, and hopefully it will work seamlessly. We will find out. All right, so this presentation is in regards to the disciplinary process and how the Department of Justice and the Office of the Attorney General fits into the disciplinary cases and process that we have. So, I am... Everything you see there, everybody. Thank you. I am Christina Jarvis, Deputy Attorney General. I've been with the Attorney General's office for about 10 years now. For the last 3.5 years, I have been the Northern California liaison to the Board of Pharmacy from the Office of the Attorney General, and I am located here in the Sacramento office, thus Northern California.
Good morning. My name is Nicole Trauma. I'm the Deputy Attorney General liaison for the Southern Division. I've been with the Attorney General's office for 13 years. And my home office is in San Diego. So first, we're going to talk to you about our mission statement. Government Code Section 11040 is the code section that states the Attorney General's office represents state agencies and employees in judicial and other proceedings. This is the Attorney General's Office mission statement on the slide here. And I want to emphasize that in all of our cases, our job is to represent the boards or bureaus of the Department of Consumer Affairs to the best of our ability, and also to do so the right way. We're the good guys, and anytime we need to make a judgment call, we want to make sure that we make the decision that upholds these principles. Similarly, here is the licensing section's mission. There are very good reasons to enforce licensing laws that are summarized here, but I always emphasize that while our primary goal is to protect the public, by doing so, we also protect good practitioners by protecting the integrity of their chosen profession.
So just as an overview, the flow chart you see now gives you an idea of the overall flow for a disciplinary action from when the Attorney General's office receives the case, then prepares the pleading, sends that pleading to board staff for review and ultimately filing, and then serves that pleading on the respondent so that they have notice of the pleading and the action against them. We then will wait for the respondent to file a notice of defense. If they don't do so, we would take a default. A default would mean that their license would be revoked, essentially automatically, because they failed to appear. At that point, if they do file the notice of defense, we would move on to the discovery and settlement negotiations process, and that all includes phase one here, ending with the actual setting of the hearing. So phase one can take quite a bit of time, which is probably why it has the most boxes.
And next is phase two, which is our trial preparation. Then we proceed on to phase three, the actual trial. Then the administrative law judge issues a proposed decision, which then goes to the board, and the board makes a decision to either adopt or reject the proposed decision. So we'll revisit this chart later.
So for the purposes of this presentation, we're going to focus on accusations only, because accusations do make up the vast majority of the cases that the Attorney General's office handles, both for the Board of Pharmacy and then all of the other boards and bureaus that we represent. When an investigation referral for prosecution arrives at my desk, I will first review the evidence. So I review the investigation report, I review the attachments. That can sometimes take quite a bit of time. There can be many, many attachments. I make sure that I believe that I can prove the violations of pharmacy laws or regulations that are set forth in that investigation report. If I do believe that there is sufficient evidence to prove the violations of pharmacy law, I will then draft the accusation document. And that's a document everybody's familiar with that starts the case and gets sent over to the board. That accusation is a public document. It's online, it's on the Breeze webpage, and it's linked under each individual's license once the accusation is filed against them. Now, the accusation will set forth, as you see on this slide, first the jurisdictional information, showing that the board has the authority over the license and what statutes give the board that authority. Then it will set forth the license history to show which license is held by the respondent, how long they have held it, and sometimes multiple licenses. You may have a pharmacy license, a sterile compounding permit, and then maybe the owner of that also is a pharmacist, and so you then have a pharmacist license as well. And then after the license information, you will get to the relevant statutes and regulations. As you all may know, the pharmacy board book is quite large. We don't put all of the statutes and regulations in there, but anything that's going to be relevant to this particular case should be included in this section. Now, the pharmacy statutes are found at the Business and Professions Code, section 4000 et sec, or 4000 and everything after that. And then regulations are found at the California Code of Regulations, Title 16, section 1700 et sec. After the relevant statutes and regulations, we will then get to the charging paragraphs. This would be your first cause for discipline, the second cause for discipline, et cetera. This is where we get to what I call sort of the meat of the accusation. This is where we're trying to explain to a licensee how the facts of this case apply to the violations that we believe that we can prove. Sometimes, before we get to the causes for discipline, we will have a section for general background facts first. And that's just the facts that are fundamental to understanding the charges that will come next. And the purpose for that, on one hand, is to prevent repetition. There's no point in repeating the same facts over and over in each cause for discipline if we have the same set of facts that go to multiple violations, but also for clarity, so that you can see kind of what the story is of this case, and then you get to where the violations are pled. Now, then we would send the draft accusation over to the board for review by staff, and then signature by the executive officer. Once it's signed, we will then serve that accusation on the respondent. Until that document is signed and then, fairly quickly thereafter served, it is not public. It's only once it's signed, it then goes onto the website and becomes public. Service is by U.S. mail and certified mail. The Administrative Procedures Act and the Government Code requires service to be on respondent's address of record with the board. And this is because the licensee is required by the California Code of Regulations, Section 1704, to keep their address current and then to update any changes of address within 30 days. This is one reason of several that it's very important for licensees to keep their addresses up to date. It's really unfortunate when we send out mail to a licensee and then we get, the bounce back, and we know they don't actually have a copy of this accusation in their hands. But by law, that is our requirement, and they are considered served at that point. And that's when the rest of the process occurs. So what's the point, right, of all of this, of drafting the accusation, of making it clear? The point is due process. We want to explain, again, as clearly as possible for a non-attorney exactly why we have jurisdiction over the entity and their license, which statutes or regulations that we believe have been violated, and how the facts that we believe we can prove occurred at a hearing violated those statutes and regulations. This document creates a framework for the entire case, for the administrative law judge or ALJ, for the respondent, for their attorney, for us, and it puts the respondent initially on notice of the charges against them so that they can respond to the accusation adequately.
So next, the respondent must file a notice of defense, or NOD. This is a really short form that we provide them with the accusation, and it simply says that they got the accusation, they want a hearing, or they want to reach a settlement, or they want to surrender their license. It gives them space to provide their preferred contact information, as well as any attorney contact information if they have an attorney. And this also serves as the licensee's request for an administrative hearing. Without the notice of defense, we proceed to a default decision pursuant to the Government Code. Once the board issues the default decision, the licensee is served with a copy of that default decision. If the licensee failed to file a notice of defense by mistake, inadvertence, excusable neglect, they can petition the board to vacate the default. But there are strict deadlines. This has to be filed within 7 days of service of the default. And once the effective date of the decision has passed, the board loses jurisdiction to act further in the case.
So assuming that the notice of defense is filed, once it's received, again, in the Attorney General's office, we will set the matter for hearing by filing a request to set with the Office of Administrative Hearings. Now, if you recall back to that flow chart, there are a lot of things between receiving the notice of defense and setting the case for hearing. The problem is when you do a request to set for hearing, which is submitted, it's actually uploaded via secure file transfer. First, you're required to meet and confer with the respondent or opposing counsel. You have to take into consideration the availability of OAH, the administrative law judge, the deputy attorney general, the respondent, opposing counsel, any and all witnesses. You have to estimate the length of hearing, and if your hearing is going to be 4 days or longer, you will be required to attend a pre-hearing or settlement conference. Now, the OAH offices sometimes do this slightly differently, but here in Sacramento, our pre-hearing and settlement conferences are always done on a Friday, approximately 4 to 6 weeks prior to the hearing. So when you're setting a hearing, if you have to have the pre-hearing or settlement conference, you have to get 2 dates from the respondent, opposing counsel, and then also the client representative. You have to have that Friday, 4 to 6 weeks before the trial, and then all of the trial days. As you can see, this sometimes can be very difficult to accomplish. We always try to take the first possible date from the Office of Administrative Hearings, but sometimes that date can be, 4 months, 6 months, 8 months away. So when you're looking at that flow chart again and you say, well, but what about the mitigation part? What about the discovery part? That can all happen while we're waiting for that hearing date. So the best practice is to set that hearing as soon as possible, and then that gives you other deadlines throughout the case. So once the Deputy Attorney General has met and conferred with the respondent and opposing counsel, and if they're not able to meet and confer, if you can't get a hold of somebody, not responding to emails, anything like that, then the Deputy Attorney General also has to file a separate form explaining why you failed to meet and confer. So sometimes that process in of itself can also take a while. So the pre-hearing conference, that's where the parties talk about the schedule for the hearing, exhibits, pretrial motions, anything like that, anything that needs to be determined before the first day of hearing. So if you have witness schedule issues, if you just need to figure out exactly how the trial is going to progress, that's where you discuss it. The judge will then send out a pre-hearing conference order. Then at the settlement conference, the administrative law judge will tell us what they think of the case and encourage settlement. And this can be really useful at this point because you've just had the pre-hearing conference, you just set forth all of the process that needs to happen in the next 4 to 6 weeks, and both parties can see, we're getting down to sort of brass tacks. We're either gonna settle it today or we're going through the next, 4 to 6 weeks of trial process.
So next we're going to talk about discovery and settlement. Government Code Section 11507.6 provides the exclusive right and method of discovery in administrative proceedings. So typically what will happen is the Deputy Attorney General who's assigned to the case will send the investigative file to the respondent or their counsel. And usually this is done before setting the matter for a hearing. It's difficult for the parties to really understand how long a case is going to take and to analyze which venue is appropriate without having the opportunity to review all the evidence. So this would include the investigative file and any documents that were used with regard to the investigation. Parties are entitled to obtain information upon written request made to the other party prior to the hearing. So that's within 30 days of service by the agency of the initial pleading or accusation, or within 15 days after service of an additional pleading, so perhaps where we've amended an accusation and added on an additional investigation. Once the discovery has been served, typically the respondent will provide mitigation, and then the agency decides whether or not to extend a settlement offer through the assigned DAG to the respondent. And generally a settlement is offered, even if that settlement is simply to negotiate a surrender of the license, rather than proceeding to a hearing. Then the parties will negotiate on the settlement terms. And there are really a lot of great reasons to settle a case. As you can see here on the slide, I've listed a few. The first is risk avoidance. You never know what an administrative law judge will decide. It saves time and expense, both in paying attorneys for both sides. And instead of waiting for months for the hearing to occur, then a proposed decision to get issued, and then for the board to vote, you can have a final resolution within probably 60 days. Lastly, stipulations are good. Settlement agreements can contain any terms of the agreement that are not contrary to policy or law. So parties can get really creative with the terms in the settlement, and they can really tailor them to the violations that are at issue. The parties can negotiate on those terms. And finally, the respondent is agreeing to abide by the terms of that agreement.
So when we say that we can have any terms that are not in violation of policy or law, we always refer to the disciplinary guidelines. Disciplinary guidelines are developed and enacted by the board pursuant to the California Code of Regulations, Section 1760. These disciplinary guidelines are completely vital to any case from start to finish. If there's one thing that I can leave everybody with today listening to this presentation is to review the disciplinary guidelines. Know what's in them. There's a lot of really good information and really important information. The disciplinary guidelines give direction to everybody involved in a case. Board staff, to myself, I personally keep them on my desktop, on my computer, handy because I look at them almost daily. It's really nice to have just a really quick reference when I'm talking to opposing counsel or a respondent who, has never been through this process before and needs a little bit of assistance and guidance as to what the board is expecting from them once they receive that accusation. The disciplinary guidelines are useful to opposing counsel as to what they can expect in any given case. And then maybe most importantly, maybe not, the disciplinary guidelines are also reviewed by administrative law judges or even superior court judges in the event of a writ, because these judges may review and rely upon the disciplinary guidelines. They're an insight into sort of the mind of the board, and the administrative law judges in particular are going to rely on those disciplinary guidelines for any and all probation terms. In most cases, administrative law judges will not deviate from what's in the disciplinary guidelines.
So what is in the disciplinary guidelines? The disciplinary guidelines set forth the factors to be considered in determining whether the penalty should be minimum, maximum, or intermediate, consistent with the board's primary purpose, which is to protect the public. There are 17 factors. A few factors that are almost always relevant in a case are going to be the actual or potential harm to the public or consumer, or financial benefit to the licensee, prior record, the nature and severity of the acts at issue, and evidence of aggravation, mitigation, and rehabilitation. Next is a list of the types of evidence the board wants to see in considering whether settlement is appropriate, which includes things like letters of recommendation, performance evaluations, and evidence that the respondent's substance abuse disorder is being treated. This gives respondents directions as to what to provide to the board for settlement purposes. This is their mitigation evidence. And perhaps most importantly, in the disciplinary guidelines, the board has identified 4 categories of violations. Category 1 through 4, with 1 being the lowest level of violation and 4 being the highest. Each category outlines examples of violations, but each case must be considered on its own merits. Additionally, each category and the recommended discipline for each category contemplates only 1 violation. Where there are multiple violations, that will raise the entire case up to the next category. The maximum discipline in every category is revocation. In every case where there are violations of pharmacy law regulation, revocation is a possibility. The disciplinary guidelines also contain sample language to be included in decisions and order, and this is to ensure consistency.
So category 1, this is the lowest category. It has a minimum penalty of revocation stayed with a 2-year probation term. Cases are really rarely going to be appropriate for a 2-year probation period. And that's because generally there's going to be more than 1 violation of pharmacy law in any case. Under Business and Professions Code Section 4309, a respondent who is placed on probation for 2 years, or actually anything less than fully 3 years, so if it's 35 months as well, they can petition the board for early termination of probation after serving only 12 months of probation. That's early termination or modification of probation. If the probation term is 3 years or more, 36 months or more, then the respondent cannot petition the board for modification or early termination until 24 months of successful probation. This seems like a long time, but when you're on probation, and frankly, even when you're not, the years do really fly by. And so having that extra time for the probationer to really show that they have improved their practice, that they have changed is really important sometimes. Some examples of violations in Category 1 are violations of record-keeping statutes or regulations, violations of their scope of practice, violations of inventory control requirements, or failing to adequately supervise staff, ancillary staff, or to ensure the security and sanitation of the premises.
Next, we have Category 2. And with Category 2, the minimum penalty is revocation, stayed, 3 years probation. There is a minimum of 5 years if the violations involved self-administration or diversion of controlled substances, dangerous drugs, or alcohol. And you can see the rationale for this as set forth in the slide, and I will add that my understanding of the reasons for the 3 to 5 year difference is that studies have shown that if an addict can remain sober for 5 years, their chances of remaining sober for life greatly increases. Some examples from the Category 2 violations are failing to report to cures or regulatory agencies, violations of quality assurance, self-assessment obligations, and failures to clarify erroneous or uncertain prescriptions.
Now, Category 3. With Category 3, the minimum penalty is revocation stayed with a 90-day suspension of licensure, and then 3 to 5 years probation. Now, it is uncommon to enact the suspension unless there's a particular reason to do so. If there's something like in the last category we were discussing about, in Category 1, in regards to failing to keep the premises clean, it might be appropriate to enact a suspension of licensure to give a pharmacy time where they're not functioning as a pharmacy to clean, to eradicate pests. So when there is a reason for a suspension, then that's a good reason to impose it. But unless there's a reason like that, it's usually not appropriate to impose such a suspension. And then 3 to 5 years probation, similar to the last category. Now, Category 3 violations generally have a greater potential for harm. They'll have more imminent harm or more serious harm than Category 2, or they are multiple and repeated violations of the Category 2 violations. Some examples that fall into this category are, again, failing to exercise corresponding responsibility, violation of laws governing controlled substances, dangerous drugs, et cetera. This would also include repeat or serious diversion or self-administration, or dealing with or dealing in adulterated, misbranded, or expired drugs. There are many, many more violations in this category. If I sat here and read them, I would probably be here for the rest of the day. This is probably the largest category. Category 2 does come close.
Now, with regard to Category 4, the only penalty appropriate for Category 4 is revocation. Some examples include possessing controlled substances for sale, transportation, importation, or use of a minor for unlawful sale, and criminal convictions involving same. Or, remember, repeated or serious violations that fit into one of those other 3 categories.
And in each of these slides discussing these categories, we've told you the minimum penalty for that's appropriate for each category. And that's because the maximum penalty is always revocation. Any violation of pharmacy law may carry a penalty of revocation depending on the facts and circumstances of that case. So the disciplinary guidelines also set forth, and we touched on this a little bit earlier, but the model language, both for settlements and for proposed decisions written by the administrative law judges. This is because consistency in probation terms is appropriate, even while each case is being decided on its own merits. So for example, you could have 2 identical driving under the influence or DUI cases. Both of these individuals maybe get caught in a DUI checkpoint. They both have a 0.09% blood alcohol content, just above the legal limit, and they both get convicted of DUIs. All other factors being equal, these 2 should probably be treated the same. And when I say other factors, I mean prior history of other crimes, things like that. However, you could also have a driving under the influence who maybe runs a red light, maybe crashes into another car, causing serious injury or death, has a 0.3% blood alcohol content. Now, that person should probably be treated differently than the 2 people in the previous example. In each of these scenarios, the individual, the licensee, is likely to be convicted of DUI, when the criminal court is going to handle both of these individuals essentially the same. But the purpose of describing these scenarios is to show how different, for purposes of a licensee who we are trusting to handle controlled substances and dangerous drugs in a pharmacy, just how different those two, the exact same conviction can be. Now, there are 16 standard terms in the disciplinary guidelines that should be ordered in all cases without exception. These include obeying all laws, filing quarterly reports to the board, cooperating with board staff, cost recovery, things like that. Now, there are 26 optional terms of probation that should be ordered in the appropriate cases. Now, some of these terms may work together, such as abstaining from drugs and alcohol, and then also the biological fluid testing requirement. If the board is going to order a respondent to abstain from drugs or alcohol, but then does not order the biological fluid testing, how can we monitor or ensure that that individual is actually abstaining? So if we have one, we really need to have both. Other terms may be designed to educate. We have remedial education terms, ethics course terms, potentially supervised practice, or if it's a premises license, having a consultant that has to actually come in and review the operations of the pharmacy on a regular basis. All of these terms, however, working together or not, they're designed to protect the public specifically. In a settlement, the board can ensure that the appropriate optional terms are included in that stipulated order. With a proposed decision, the Deputy Attorney General, like me, can make that request. I can request optional terms, but I don't know when I walk out of that hearing room if the ALJ is actually going to order them. There is no guarantee. There have been times, and I had one case where I requested specific terms, the ALJ ordered them. We did not realize that the ALJ ordered both of the specific terms that I had requested in the alternative, and they contradicted. And we ended up in a writ, and this was not before the Board of Pharmacy, but we ended up in a writ solely because the respondent couldn't comply with both terms. And I had asked the judge one or the other, and she didn't understand that. And so we want to make sure when we, that's another reason for engaging in settlements and engaging in stipulations. So my last 3 words on this slide, any creativity in probation terms requires a settlement.
Now we're going to talk about due process. I really want to emphasize that all of the process that we've outlined here today have 2 guiding principles that must always be held in balance, and that is due process to the respondent and protection of the public. And protection of the public is the highest priority for the board. Where other interests conflict with the protection of the public must be paramount. The licensee receives their license from the state, and the state has the right and the responsibility to ensure that licensees are competent and trustworthy. The licensee has a property interest in their license and cannot be deprived of that interest by the state without due process of law. So due process, that's going to require that the licensee have a reasonable notice of the charges. So what Christina was discussing earlier with the charges set forth in the accusation, that they have notice of the time and place of the hearing, and a fair hearing on the charges before the license is affected in any way.
So now we're back to this flow chart. Now, everything that we've talked about so far this morning fits into the phase 1 light blue portion of this slide. And then potentially the middle dark blue section, phase 2, the trial preparation.
And next we're going to talk about the bottom portion of the flow chart, which is the trial or hearing process, phase 3.
So the hearing must be held in accordance with the Administrative Procedures Act. This is set forth in the Government Code. A hearing is a public proceeding. Anyone can watch the hearing, and any document submitted is a public document unless the court specifically orders that document to be sealed. Now, with COVID, this has been a little bit interesting because we have also been doing virtual hearings and we're uploading our documents to the court. It's a little bit harder for the public to come watch a virtual hearing, but they can contact the court and get access to the Zoom link that we're using now. And you do not have to provide any information in order to do so. Again, it's a public hearing, so you don't have to provide your name or why you want to watch or anything like that. As for the sequence of the hearing, the presentation of testimony and evidence is set forth in Government Code Section 11513. The Deputy Attorney General will go first in presenting the evidence. The burden of proof is on us, representing the complainant, who's your executive officer, to prove that what we have alleged in that accusation is true. The DAG will then call witnesses to testify under oath, will present their documents to the court and request that they be admitted into evidence. Some of the documents we submit for that purpose are patient records. As you know, working in a pharmacy, you have issues with patient records and patient confidentiality that the Deputy Attorney General's office, as well as the Board of Pharmacy, has to take into account when presenting this evidence. This is part of the board's mandate to protect the public. We also protect the patients whose rights we are also trying to protect. Once the DAG rests their case in chief, the respondent, or really usually their attorney, gets to present their own defense. They will also call witnesses and present documents before the court. Additionally, the respondent may call an expert witness to counter what the board's inspector has testified to. Once both parties have completed their case, there is then closing argument, which is either orally or via written brief submitted after the hearing. When closing argument is via written brief submitted after the hearing, it's usually an extended process. I did the math recently, and you can generally expect it to be 135 days from the last day of hearing for you to actually receive the last brief and the case to be submitted to the judge. That can be shortened with the assent of both parties and the court, but when you're talking about doing written briefs, you're generally going to obtain transcripts. Then you're going to get 30 days to write your brief. After you receive the transcripts, there will be 30 days for the respondent or their attorney to write their own brief, and then the Attorney General has approximately 15 days to respond. Now, that's a general schedule. The court will set their own schedule, and they may not agree with that sort of general schedule, but that's a starting point for further discussion. Once both parties have completed that case, the administrative law judge will render a proposed decision. They have 30 days to do so once the case is fully submitted to them, and then that goes to the board for consideration. Now, one little caveat here, we cannot force the respondent to attend the hearing. Just because they filed a notice of defense, you don't know what may have happened in their life since they filed that notice of defense. They may choose not to appear. They may not be able to appear. If so, unless they contact us, they will be defaulted, just exactly the same as if they had not filed the notice of defense earlier in that case.
So now we're going to talk about the burden of proof at hearing. Okay. Clear and convincing evidence means the proof is clear, explicit, and unequivocal, so clear as to leave no substantial doubt and sufficient strong to command the unhesitating assent of every reasonable mind. So what does that mean? It means there's a high probability that it occurred. And the applicable standard of proof depends upon the nature of the license at issue. It has been established by case law that accusations against professional licenses, such as a pharmacist license, requires clear and convincing evidence. I'm sure you guys have seen that Ettinger case in your decisions before. Pharmacist interns are also going to be a clear and convincing evidence standard because it's considered a professional license. A professional license is one where the licensee has fulfilled extensive education, training, and testing requirements, where they've invested a lot of time and effort to get that license. And the burden of proof to prove that clear and convincing evidence standard is going to be on the complainant, which is the executive officer of the board, for those accusations. But it switches to the licensee when they're petitioning before the board on petition for reinstatements and petition for reduction of penalty cases.
The other type of burden of proof that we see in licensing cases is the preponderance of the evidence standard. A preponderance of the evidence calls for a lesser degree of the probability that something occurred. Essentially, that it's more likely than not that the event occurred. Now, occupational and non-professional licenses are held to a preponderance standard. A non-professional or occupational license is one where the requirements necessary to obtain the license are minimal, and the holder's investment in training, education, and other personal qualifications required to obtain the license is rather small. And I emphasize personal qualifications because you have pharmacies. Obviously, it does not take a small investment to open a pharmacy. It's a large financial investment. But we don't count financial investments. This is your personal and professional process to obtain a license that we're taking into consideration here. So all premises licenses are a preponderance standard. You do not have to have any particular education, training, or experience in order to apply for a pharmacy premises license. Now, there is currently a split in decisions before this board as to whether pharmacy technician licenses should be considered a professional license or an occupational license. The board has adopted decisions in the past with either standard. Pharmacy technicians are required to get training and education prior to obtaining their license, but they are not allowed to exercise professional judgment when they are performing their tasks as licensees. So the best practice for Deputy Attorney General is to always seek to prove the case to a clear and convincing standard, but under the legal standards that we have set forth here, it does seem clear that the appropriate standard of proof is a preponderance of the evidence standard for a technician license.
So after the hearing, the administrative law judge will write a proposed decision, and then that gets sent to the board. It is due within 30 days after the submission of the case. The board then reviews the decision and can either adopt or reject it, non-adopt it. And I believe you've all been a part of that process before, so I won't belabor it, except to say that that process in and of itself is more due process for the respondent. And if after hearing and the board's decision in order, the respondent does not agree with that decision, they can request reconsideration before the board, or they can file a writ in the Superior Court to challenge that decision. And then again, that affords respondent additional due process. And this is generally the conclusion of the disciplinary case process once the final decision is issued.
So we have now completely gone through all three phases of the flowchart we showed earlier, from phase one, where the Attorney General's office receives the case, through trial preparation, potential settlement in phase two, to the trial and outcomes that may occur from that trial in phase three, which includes the proposed decision being considered by the board. We thank you for allowing us this time and your attention to this presentation about the Attorney General's role in the disciplinary process.
Thank you.
Thank you, both of you. This is a very informative presentation. I believe it serves as an important reminder to all of us about the due process built into the process. Members, do you have any questions regarding the presentation? I think everyone really enjoyed it. I found it fascinating.
Thank you.
I think we're ready for public comment. Before we move on to public comment, I'd like to remind everyone that public comment is not meant to be a question and answer period, rather an opportunity to provide comments on the presentation. Ms. Jarvis and Ms. Trauma, you're under no obligation to answer any of the questions. You're probably pretty familiar with that. We'll begin with public comment from individuals participating in the Sacramento location. Do we have any public comment from people in the room? Seeing none, moderator, we're ready for public comment for people participating via WebEx.
Thank you. This is the DCA moderator, and we've opened up the WebEx Q&A feature to facilitate public comment. If you'd like to make a comment, you can either raise your hand by clicking on the hand icon, or you can look for the question mark icon, typically in the lower right of your WebEx screen. Click that, type the word comment into the text box, and click send. Each person will have 3 minutes with a 10-second warning. And one moment while I gather the comments and the hand raises. And our first request to speak is from someone logged into WebEx as Joe Gracella. Joe, I'm going to send you a request to unmute your microphone and you will have 3 minutes. And Joe, did you get a little pop-up saying unmute me or request unmute? There you go, you're unmuted.
I have a suggestion,
Great.
and as you heard, this is a very complex case management, and it's very expensive, very long, and it's not the most efficient way. The problem here is the pharmacists can't tell their side of the story because there's no pharmacist available for them to tell his side of the story as you would do with a violation. So what ends up happening is this goes directly to the Attorney General. So if you want to tell your side of the story, you're going to have to go to a pre-hearing before the trial or administrative hearing. That's about 9 months later, costs about $100,000 in legal bills, and the judge really doesn't have any power over there. So it ends up having to go to a trial. That can take up to 10 days, costing over $200,000. And then on top of it, the Board of Pharmacy bills the pharmacist maybe as much as $100,000 in bills that we have to pay for. So this really isn't a fair due process because the pharmacists simply can't afford $300,000 to $400,000 to tell their side of the story. Most pharmacists will just simply give up at that point because they got house bills. They can't afford these bills. Even if they got mitigating information and circumstances, even if the board's wrong, they just give up. So it really isn't a fair process. So how do you correct this? The solution is before it goes to the AG's office, you have a pre-enforcement meeting, and all boards of pharmacy have a pre-enforcement meeting. Including even the California Medical Board has a pre-enforcement meeting. Usually that consists of about 3 board members. They listen to any mitigating information, decide if it should go to the AG's office. Takes 30 minutes to an hour, enough time to answer questions and hear it. If the 3 board members decide it should go to AG's office, then at that point, the AG can easily negotiate probation without doing all this that you just said above. This all can be done rapidly, efficiently, fast, saving money for the pharmacist and also saving money for the taxpayers. Now, the whole board voted on this pre-enforcement meeting a couple years ago, and it's supposed to be brought back to the pre-enforcement model. It was supposed to be discussed here at this enforcement committee. But until now, we haven't had that. Do you think that is going to be a discussion in the near future?
Thank you.
And as this is the moderator, as a reminder to our call-in users, if you would like to make a comment, you may press *3 to raise your hand. Are there any further requests to comment? I do not see any other requests. If you would like, I can close the public comment feature.
Please do. Thank you.
You're welcome.
Members, do you have any additional comments before we move on to the next agenda item? Great. Thank you, Christina and Nicole.
Thank you, guys.
Thank you very much.
We're going to move ahead to our second presentation, agenda item 5, presentation and discussion on board's inspection program. Strategic Objective 2.3 of the board's strategic plan calls for the completion of routine inspections of all licensed pharmacies at least every 4 years to proactively assess pharmacy operations and educate licensees. On an annual basis, the committee receives a presentation providing a summary of information detailing accomplishments towards this goal. I'd like to welcome Assistant Executive Officer Julie Ansell. Congratulations, Julie, on your new position. and to who will be providing an annual presentation. I think Ann Sodegren, our executive officer, is joining her at the table.
Thank you. Again, I'm Julie Ansel, and Assistant Executive Officer for the board, and thank you for the time providing you with our inspection information for this fiscal year. Next slide, please. Moderator, I think you're one ahead of me. Could you go back one to the one that says mandate?
My apologies.
No, perfect. Thank you so much. So I want to begin by saying, why do we inspect? And we inspect because we're here for consumer protection. You know, sometimes I think people focus on the disciplinary side of consumer protection, and that's absolutely a key component of consumer protection, but it's not the only component. And to that end, you know, inspections that we do in licensed facilities really provide a significant opportunity for education as part of the process. And in fact, the board has established a policy goal to inspect all pharmacies every 4 years. And these inspections really provide inspector staff the opportunity to observe, evaluate for compliance, but also provides an opportunity for education to the licensee population. And I wanted to take a moment to remind everyone some of the really fabulous tools, I believe, that the board has available in order to assist in helping prepare a pharmacist for an inspection. We have our Ask Inspector program. We have a webinar on our website that goes through the inspection process. We have a brochure that's available. Of course, our script newsletter can always be accessed. And finally, the board has the self-assessment. And truly, this is really the ultimate tool for a pharmacist and a pharmacy. And it's really a true roadmap to compliance when used appropriately. Next slide, please. So this slide shows just some of the typical items that an inspector might review and observe when visiting a pharmacy. They may observe for consultation, notice to consumer poster, checking to see if the name tags are available, and overall professional interactions among staff. And in general terms, we're basically observing what's happening in the pharmacy upon entrance. Next slide, please. Within the inspection, we're going to review specific items. Inspectors will ask to see information and confirm compliance with various aspects of pharmacy law. They may be reviewing the self-assessment with the licensee, is the licensee reporting to cures, review of policy and procedures, review of the QA policy for medication errors, but just going through some specific documents that need to be looked at while they're in the pharmacy. Next slide, please. So what is inspected? The board will assess the physical state of the pharmacy as well and check on items such as the will call area, the shelving in the pharmacy, observing for expiration dates, expired medications, possibly expired ingredients in the pharmacy. Is the pharmacy clean? Is it neat? Is it orderly? Or is it cluttered? And basically just a full assessment of the physical state of the site. Next slide, please. And as I mentioned earlier, you know, these inspections really provide an incredible opportunity for education, and the board welcomes questions from licensees during an inspection. And as part of all inspections, there's an expectation from our inspectors on our staff that they do provide helpful and educational information to the licensees. Some current topics that may have been reviewed this past year might have been community staffing requirements, possibly reminding licensees of the 2 hours of CE law that is now required in law and ethics, review of the inventory reconciliation requirements, electronic prescription revisions under BPC 688, And oftentimes, we also have our inspectors discuss what's happening at the board level, mentioning what has happened in the past year during the Standard of Care Committee or the Medication Error Reduction Committee, or even here, the Enforcement and Compounding Committee, and keeping those licensees educated on what's happening at the board level. Again, always reinforcing the importance of the self-assessment, and always referring back also to our website, as there's so many good resources there for a licensee. Next slide, please. So now we're going to dive into some of our progress, some of our numbers from this last year. This slide provides a 5-year history of the total inspections completed across our organization. This last year, pharmacy inspectors conducted 2,837 inspections during this past fiscal year. And just note that the way we pull our data, it's a little bit of a interesting process. So this data is through June 16th. It doesn't go through the entire fiscal year. Those last 2 weeks are missing. But if you go and you look at the 5 years, the board is actually averaging approximately 2,900 inspections annually over the past 5 years. Next slide, please. So here we break down, go a little bit more granular. Out of those 2,837 inspections, what does that look like? We broke it down by inspection visit type. Inspectors are prompted to inspect a pharmacy for a number of reasons. We may be visiting a pharmacy for a routine inspection, might be triggered by a consumer complaint, the pharmacy may be on probation, or visiting the pharmacy for an annual compounding renewal inspection. And as you can see from the slide, the majority of our inspections are completed in pharmacies. That's our largest site licensing program. Sterile compounding also makes up quite a large percentage as well. It's about 1/3 of the inspections that we do. Next slide, please. The remainder of our board inspections are made up of outsourcing inspections and then our other category. Outsourcing are those 503B facilities, do bulk compounding, manufacturing. Those are mandated inspections, just like sterile compounding for the renewals. Most of those are out of state. They're pretty complex inspections, time-consuming, and require a significant amount of travel for the inspector as they're going to multiple states throughout the U.S. And then we have our other category, the bulk of which are ads or automated drug delivery systems. These are either new ads coming up into locations and being installed, or they are ads that are requiring an updated inspection, a change of ownership, or a change of location of the actual machine. Next slide, please. So this slide kind of drills down what we've been able to accomplish for our routine inspections. Again, we talked about the board's policy goal of trying to conduct a routine in each pharmacy every 4 years. And this year, we were able to conduct 1,316 routines in fiscal year 22-23. I think I went to the wrong one. Sorry about that. I went ahead of myself. So that 889, those were actually true routine inspections where we were simply at the pharmacy for no other reason but a routine inspection. And then we have another 427 routines where we were there for another type of visit, but also provided a routine inspection. We were there for possibly a probationer, a complaint investigation, and or a sterile compounding visit. Next slide, please. So this displays basically what are the outcomes of these inspections, right? When we look at true routine inspections, meaning staff were there solely to perform an inspection, there are 3 outcomes. of an inspection. You can have no violations at the end of an inspection, you can be issued corrections, or you can be issued written notice. And so for those routines that were true routines we talked about earlier, just over 50% received no violation, another 46 issued corrections, and then 7% were issued a notice of violation. And these percentages, they don't necessarily add up. They'll add up to a little over 100% because in some pharmacies, they're going to receive a correction and a violation notice in one inspection. And then on a complaint investigation, 48% received no violation, about 30% received a correction, and then another 24% received a written notice. And then on probation inspections, those yield pretty good results in terms of compliance because we are working with the licensee hand in hand. And in those routine probation inspections, we had 81% no violation, 16% correction, and then 3% received a written notice. Next slide, please. So these are the top corrections on routine inspections that we noticed when we were in pharmacies these last years. And what I want to talk about is, you be mindful of one violation may have a spectrum of different behavior within that violation. And one example I can give is when you look at standards and security, 1714, CCR 1714. That can be anywhere from dirty dishes in the sink to mineral deposits in the sink, a dirty sink, but then it starts kind of going up, right? Maybe there's no sink at all. Maybe there's no hot water, right? And then the shelves are dusty and the pharmacy is very cluttered. So you can see that, there's a difference between one dirty cup in the sink versus the entire pharmacy having dust and dirt and filth everywhere. So it's definitely a spectrum. Also within that, you could have something even more egregious where there's a rodent infestation, right? So definitely a spectrum within one violation can occur. And we have labeling violations in this section, the font, possibly that there's generic is dispensed and they're not noting the brand name on the label. Duty to consult, we'll talk about that a little bit later. I do have a specific slide because we're very focused on patient consultation, so we'll run through that. Inventory reconciliation, license display, administering vaccines. We have instances where the immunizing pharmacist doesn't have a most recent BLS certification or CPR certification, or maybe they're missing their immunization CE at the time when there are immunizing patients. And the rest are fairly self-explanatory. Next slide, please. This is then top violations on routines, and for the most part, they're pretty similar. There's only a couple that are a little bit different. One is there's 4115 F1 or tech violation ratios. Again, this is not in any specific order in terms of top violations, but just wanted to give you a feel for, again, what we see in terms of written notices when we go in for these routine pharmacies. Next slide, please. So I'm coming back to consultation. The board's very focused on the importance of consultation in pharmacy practice. And what this reveals is that across all the routines that we did this past fiscal year, we went into 94 pharmacies that had issues with patient consultation. And again, I'm talking about a spectrum, right? It wasn't just no one was doing consultation. There's a spectrum of violations. So I kind of delineated here what those were. And so 15 out of those 94 inspections, the inspector, was there physically at the pharmacy and they actually observed the consultation was not occurring, or they observed that a pharmacy staff, either the tech or the clerk, were screening for consultation. And then in another 33 inspections,
the inspector found that the site wasn't providing written notice of consultation on delivered or mail order prescriptions. And then thirdly, 46 of the 94 inspections found that the written notice of consultation didn't meet all the requirements or lacked one or more elements. Specifically, excuse me, sorry, I clicked the wrong button. Specifically, that those required elements that might have been missing are the phone number on the notice, the hours of operation. Maybe they're open 40 hours a week, but they're not open on Saturdays. So there's just one element. They're providing it to the patient, but they're not providing all the information to the patient. Next slide, please. So this provides you with a really nice pie chart of our inspection summary. I wanted to just summarize what we've been able to accomplish up to this point this year. And this data shows that 69% of the board's population has received a routine inspection. This doesn't include anybody that was licensed this year, a pharmacy. And again, this is in the past 4 years. Okay. Next slide, please. So I think this might be my favorite slide because I'm just proud of the growth that the inspectors and management has been able to accomplish. This grid shows the year the last routine inspection was provided to a location. Again, it's the entire pharmacy population over 4 years, and it really shows the progress that the board has made in achieving this policy goal in inspecting every 4 years. When we started 4 or 5 years back, 1920, we were in every pharmacy inspecting for routine at 27%. And now we fast forward to 4 years, and we are up to almost 70% of the population. So I will say I believe that that is some pretty significant growth. On average, we've increased that availability of us to be in those pharmacies about 14%. Over the past 4 years, and we've really made it a priority, and I believe we've really taken significant strides to reach that goal. Next slide, please. Sorry. I should have been using my mouse. I'm really sorry. Okay. So this kind of summarizes it for our total licensing population of pharmacies, when was their last inspection, okay? So again, we talked about, if you look at the pie, we talked about that 69%. We know we've been in there in the last 4 years for a routine inspection. Then we have another 17% of that population. We know we've been in there for a routine in the last 5 to 10 years. And then 9%, they've received an inspection, but it wasn't necessarily a routine. It may have been that complaint investigation, probation, or a compounding inspection. And then we have 3.8% of the population has never been inspected, but those are licenses that have been recently issued. They've been issued within the past 4 years. So it's a newer population. And then we have 0.2 who have never been inspected more than 4 years, and that actually only equates to 16 licensees. So this next year, clearly we're going to focus on those that have never been inspected, those with the oldest license issuance date, the oldest inspection date, kind of focusing on that 17.9%, and that 0.2, we can knock that out. And we're just going to keep chipping away at the goal. It's just, I believe it's evident from this data that we've shown a strong commitment to achieving the goal, and we're just going to keep at it over the next year and into the future. And that's it.
Great, thank you very much. It's a
Welcome.
very, very informative presentation. Great job.
Thank you.
I'm pleased that we are seeing such progress in achieving our strategic objectives, and hopefully, maybe by the next year's presentation, that we will see that we're very close to 100% meeting the 4-year goal. I truly appreciate the efforts of all of our field staff who perform these inspections. And members, if you recall, the workload was established and performed within existing resources, so they're working very hard. Members, do you have any questions or comments for Julie?
Oh, go ahead.
That's a tremendous progress. I mean, from 27 to 70%, and I'm positive that we'll get to in 90s next year.
Thank
So,
you.
Congratulations, great job.
Thank you.
Thank you, Julie, and all your staff. Thank you. I just have a question about, I think when we were developing strategic plan, remind me, I think in my head, I was thinking that we should also try to inspect non-resident pharmacies as well as much as we can. But I don't think the numbers are including non-resident pharmacies. How are we doing with that section of the business in terms of inspections? Are we going to try to do in person? I know this is tricky with a lot of travel expenses and everything, but.
The NRPs. Yes, please.
So at this point, we're focusing on those that are in state. The non-resident ones that we're typically doing now are linked where there is a sterile compounding license and or the facility is on probation. So we're prioritizing the in-state, and then we're going to be working on developing our process for the out-of-state, but there are a lot of cost implications, and we have to kind of navigate through that because we don't have the ability to recover those costs currently. So we're going to have to figure out some of the budget pieces as well.
Thank you. Thank you, guys.
Great. We'll move on to public comment, but similar, just some preliminary remarks. Similar to our last presentation, I'd like to remind everyone present that public comment is not a question and answer session, rather an opportunity to provide comments on the presentation. And Julie and Ann, you're under no obligation to answer the questions. Let's begin with public comment with people in Sacramento. Any public comment from people in the room? Okay, seeing none. Moderator, we're ready for public comment for those via WebEx.
Thank you. This is the moderator. If any member of the public logged in through WebEx would like to ask a question or make a comment, you may raise your hand by clicking once on the hand icon, or you may look for the question mark icon, typically in the lower right of your WebEx screen, or behind the 3-dot other options if you're on a mobile device. And once you click on that question mark, you can type the word comment and click send. If you are a calling user, you may press *3 to raise your hand. Are there any, and each commenter will have 3 minutes with a 10-second warning. Are there any comments on the presentation? I do not see any comments at this time. Shall I close the public comment feature?
Please do, thank you.
You're welcome.
Once again, thank you, Julie, for an excellent presentation, and congratulations on your new position. She's now the Assistant Executive Officer for the Board of Pharmacy.
Thank you. It's a pleasure. Appreciate it.
And with that, I think we'll take a 10-minute break and come back at just a little after 10:30 to resume with a couple more presentations. Thank you. Welcome back, everyone. Thank you for being a little more patient with us. As I mentioned a little earlier, this is one of our first in-person meetings, so the break went a little bit longer than planned, and I apologize for that. We're having such a good time here in Sacramento. Come join us next time. Let's take a roll call to see if everyone's back. Renee Barker. Present. Indira Cameron Banks. Present. Sung Oh.
Here.
Jig Patel.
Here, and for the meeting minutes, I'll be stepping away between 11 and 11:30.
Thank you, Jig. And I'm here, so we have everyone present. Let's move on to agenda item 6, presentation on the board citation and fine program. Members, consistent with objective 2.2, on an annual basis, the committee receives presentations on the citation and fine program that includes information on common violations. Generally, the information shared at this annual presentation is included in the board's newsletter to provide education to licensees. About 33% of all investigations completed by the board result in an issuance of a citation. Reporting out this information is valuable to licensees on areas of operation that can result in citations. So this is part of our educational process to assist licensees. I think one thing to note for those that were here earlier in the meeting, that many issues that result in a citation and fine, very few actually result going to the Attorney General's office and for discipline. So this is a more common area that we don't really hear about in our discussions at the board meetings, because the citation and fine program is an ongoing issue, process that we're going to learn more about. So I believe Ann Sodergren, our executive officer, is going to be providing the information. She's joined at the table with our assistant executive officer, Julie. Ann, the floor is yours.
Thank you. Good morning. As we start today, I just want to talk about just a few kind of like high-level things. The first is the presentation itself includes two different data sets, and so there's some aggregate information, but the majority of the information that we're going to be providing, the data set is similar time frame as the prior one. It's through June 16. So if you notice that there are some numbers that don't match with what's in the enforcement statistics that is included elsewhere in the meeting materials, wanted to explain that that data set is a little bit different, which is why there's some difference in the numbers. But to pull together a lot of the common violations and everything, we did need a little bit more lead time, which is why it's a kind of truncated a little bit. The other thing that I wanted to just make sure we all remain very cognizant of is citations have many appeal rights. And I'll talk a little bit about those, but I just want to be very mindful of the fact that many items continue to be pending. And so we're going to try to stick to just focusing on the numbers and not get into case specifics. And that is by design, because we want to ensure that we are avoiding any potential ex parte communication in a matter that may ultimately come before the board. So I just wanted to kind of like lay out that expectation as well. So if we could go to the next slide, please. So this eye chart that you have before you is on 2 slides, and it is really kind of intended to demonstrate what the process is from the time we receive a consumer complaint until it results in the issuance of a citation. So there are many triggering events. There are many reasons that we may open up an investigation. But from the 50,000-foot view, many of our investigations are triggered by consumer complaints. They could be an internal, potentially from an inspection that is done, or it could be a notification from the Department of Justice. So those are just kind of some high-level sources. And so that triggering event then is going to result in the issuance of an investigation. And really the point of the investigation, right, is to determine whether or not violations of pharmacy law have occurred. So we have 2 different types of units. We have office staff that do investigations. Those are typically all mediated, and those are generally things that dealing with criminal convictions, sometimes administrative paperwork kinds of things that don't necessarily require pharmacist knowledge. In addition, we have our field staff that, as you know, are all licensed pharmacists. So anything that is going to be practice related and or require pharmacist knowledge, those are going to be done by the field. But the process in general is the same, right? We're doing an investigation, we're collecting evidence, we are determining whether or not there are violations, and we are doing an investigation report that is summarizing all of those findings. And we're doing that whether or not we substantiate violations. Because as you notice from the statistics later on in the report, not all of our cases result in substantiation of violations of pharmacy law, but the process is generally the same. For field investigations, it is reviewed at the front end by a licensed pharmacist that's a supervising inspector. They are making a determination and making an assignment out to the field. The field investigator, again, is a pharmacist. They are the ones that are doing the investigation. They are completing their investigation, and then they are submitting that for review. And it's going to be reviewed by the supervising inspector, who is also a licensed pharmacist. There is then a second level of review, and that is usually review performed by myself, Julie, and Cheryl Jenkins. who is our other CEA that is also present today. And we are looking at it again. So we have multiple sets of eyes reviewing an investigation to determine whether or not there's substantiation, and then determining the appropriate outcome. As Ms. Ansel spoke about earlier today, right, a single violation can represent a spectrum, right? So the violation that Julie gave, right, you're going to see that there are many times that the violation code section is the same, but the story, the investigation, the conditions vary greatly. And you even heard that in the prior one about DUIs, right? A DUI of a .09 and a .30, they are both a violation of the same vehicle code or whatever it is. Sorry, not an attorney. But the circumstances and the story behind that really show that there's a difference. And so I want to kind of highlight that, because you're going to see some codes through my presentation that you're going to see in Julie's, and you're going to see sometimes in an accusation, and that's because the story is different, the egregiousness of the violations. So once it goes through those layers of review, and then we're going to determine whether or not the outcome should be a citation and fine. So if we could go to that next slide, please. So then this talks about, again, those potential outcomes, and then you'll see that if it is a citation, we can issue a citation with or without a fine, and then we can, as part of a citation, include an order of abatement. And you'll notice that similar to the administrative case process, there is also an appeal right? Once a citation is issued, a licensee has the opportunity to appeal. They can appeal to an informal office conference, and or they can appeal through the Attorney General's office, of which there is a similar kind of process to what Nicole and Christina articulated earlier. The outcomes of an appeal could be that it's dismissed, it could be upheld, or it could result in some sort of modification to that citation. If we could go to the next slide. So hopefully setting the table in terms of what the process is helpful. So this slide kind of details out some of the relevant laws that are related to the issuance of citations. So 4314 really includes our general citation and fine authority. We have relatively new authority established in 4317.5A and B, and those are authorities for the board to issue a fine of up to $100,000 or $150,000 under certain conditions if there are where we can issue those fines to community chain pharmacies under those specified conditions. This is relatively new authority, so we are going to look at some of the data there because there wasn't a lot of data last year. So we will kind of be looking at that. And then the board also has regulations that support its general fine authority, and so those are included in the citation and the California Code of Regulations at 1715 through 1775 through 1775.4. And then you will see that the authority to issue the citation actually resides with me as the executive officer or my designee. Next slide, please. So I talked a little bit about fine authorities. We have, there's several different provisions of the law that we rely on for our fine authority. Section 125.9, which is in the General Business and Professions Code, provides authority to issue a fine of up to $5,000 per investigation. 4067 allows for the board to issue a fine of up to $25,000 per prescription if it's an internet prescription of which there was no underlying appropriate examination. In addition, we have section 4126.5. In that instance, under that authority, we have the ability to issue a fine of up to $5,000 per occurrence. So again, different than per violation, it's per occurrence. And then those two that I briefly mentioned about 4317.5, A and B, and that new fine authority. If we could go to the next slide, please. So the law lays out the factors that we need to consider when assessing an administrative fine, right? That last slide, it showed we have a lot of flexibility in terms of it. There is a maximum amount, but you will notice when you review cite and fine data, we do not always go to the maximum fine authority. And you'll see that in subsequent things. But The law details out many of the factors that we are going to be considering when we are assessing an administrative fine, including things like the history of previous violations. And why am I calling that one out specifically? Because sometimes you will hear, well, John received a letter of admonishment and Sally received a citation and fine, and it was the exact same condition. Well, we've already talked about the fact that the spectrum is very different, right? It's that same section 1714, but the story was different, the egregiousness was different. But in this scenario, when we're looking at history of violations, if John has a history of these violations and Sally does not, that might also be a reason that there's going to be a higher fine assessed. So just kind of calling that up. Next slide, please. So this is providing some overall citation and fine data, and this is where some of the data sets are going to, please don't try to reconcile this slide with additional slides because the data sets are different. So this is kind of where we are overall for the year. In terms of citations, I do want to highlight that our average days to complete has reduced over the time period. Our orders of abatement do fluctuate, and there's another slide later on where we can kind of talk a little bit about that. Fines assessed is trending up, but as you know, as I spoke about, we do have new authority to issue fines at a higher amount, and then also the amount of fines collected. You will see that is trending up as well. If we could go to the next slide. So now we're going to really just kind of talk a little bit about our fine authority and take a deeper dive. And so this is the more narrow data set. And you'll notice in the slides, we are highlighting where we are aggregating the different types of fine authorities, and then you'll see we'll be breaking some of it out so that you can see the data specific to those higher fine authorities, just in case that's helpful. Like I said, we're kind of new into this space, so wanted to provide some data specific to that so you can see how those fine authorities are being used. So in we issued 967 citations in general over the data period that's represented in this slide for under both of those authorities. If we could go to the next slide, please. So this provides a breakdown of the license types where we are issuing the fines or the citations. And so you'll see that the highest licensee population that is receiving a fine is pharmacy, followed by pharmacist. And that kind of makes sense, right? When we're doing investigations, a lot of times it's at a site. And then pharmacists are generally at those sites as well. So there's not really a lot of surprise in this data, just kind of highlighting that for you. Next slide, please. So this, again, is really showing the trend down in our issuance time. And so what that 325 days reflects is from the time the investigation was issued to the time that the citation is issued. So that's including that assignment time, that's including the investigation time, all of the review times, and the issuing of the citation. So we are able to, from the beginning to the end, have those done in less than a year. Next slide, please. So we talked a little bit about the orders of abatements. And so in May of, I think it was 2018, the board really started talking about the value of orders of abatements and really started encouraging staff to consider using orders of abatement as part of the citation process where the underlying violations appeared appropriate. So this just is a graphic representation of where we are in terms of using those order of abatements. If we could go to the next slide, please. So when we look at this, when we talk about orders of abatements, we use at the staff level, we use it in two different ways. There are times when we are going to mandate that someone do an order of abatement. We are going to say, the citation is this, and as part of that, you must do X. You must complete remedial education in medication error reduction strategies. There are other times where we are not going to mandate it, but we are going to make it conditional and say, if you decide to do this, then we are going to reduce the fine, right? So it's used as an incentive. So sometimes we are mandating, other times we are not. So when we look at this data, we have to remember a couple of different things. So we issued 181 of those. Not all of those were mandatory. 158 abatements were satisfied, right? So we can't say that there's noncompliance with that because not all of them are mandatory, but then also the data can shift over a fiscal year, right? So we maybe issued it in 1 year, but they satisfied it in the following year. So you can't do a total direct correlation, but just wanted to kind of highlight what the data shows. It does look like there is good use of abatements in those cases that appear to lend themselves well to orders of abatement. If we could go to the next slide, please. So this is just kind of generally our authority for it. When we do issue an order of abatement, there are some rules. We can't go crazy here. But if we're requiring something like continuing education, we're limited to 6 hours of continuing education as an example. There are other kinds of order of abatements that we may require as well. Sometimes it is asking them to revise their policies and procedures or ensure all staff have been trained in a specific area. Like I said earlier, the order of abatement can result in a reduction or forgiveness of the fine, but not always. Sometimes we are mandating that order of abatement. Next slide. So these are the typical types of orders of abatement that we're going to, ask for people to do. So if we have a case that does not warrant, removal of restriction of the license at the AG's office, but we feel like, this person would benefit from shoring up some of their education specific to corresponding responsibility, drug losses, those things, we may request either mandate or forgive part of the fine if they attend the board's free training, that 6-hour training on prescription drug abuse prevention. So that's an example. Sometimes we believe that the behavior indicated a pretty significant ethical lapse, maybe not something that we felt at the staff level required removal or restriction of the license, but so we might require someone to complete the ethics course as part of an order of abatement. So this slide kind of details out, just wanted to kind of talk through some of them, should that be helpful. If we can go to the next slide, please. So this talks about some of the other types of abatements that we may do. I talked a little bit about those in-service trainings for staff. Sometimes we're going to ask them to redo the self-assessment form, right? If the self-assessment that we collected as part of the evidence looked like it was maybe not the meaningful process the law envisioned, we may request that they take an opportunity to redo that and really do that important self-evaluation. Next slide. So this, again, is examples of types of abatements where we're trying to be a little bit creative and really trying to encourage that compliance and trying to address the issue at the lowest level before we have to send something to the AG's office. Next slide, please. So I talked at the beginning about an appeal process. Similar to the referring something to the AG's office, inherent in the citation and fine program and process is an appeal process. So people can apply or request an appeal to an office conference, which is a very informal process, and it's really intended as an opportunity for the licensee to provide additional information to us, right? Did we miss something through the investigation? Is there some mitigation that you want to bring forward that you did not provide during the investigative process? So there's the office conference and or the formal appeal. And like I said earlier, the formal appeal is handled by the Office of the Attorney General that was representing the board. In that case, it is going to go before an administrative law judge who is going to render a proposed decision that is then going to you all for the mail vote process to determine the outcome. Next slide. So this data shows data on the office conference and then the number that are appealed to the AG's office. So licensees have the ability to request both. So generally, if they're requesting both, we are going to go through the office conference process first to see if that results in a change. And that's a benefit to both the licensee and the board, especially from a cost perspective. But we have to recognize that this is not necessarily a one-to-one kind of thing, because someone can move from the office conference and then go to the Office of the Attorney General. That we have footnoted the data here because there was one office conference, but it included an issue at a number of stores. So we did not want to skew the data and look like that we convened a whole bunch of office conferences when in fact it was a single office conference. So we did adjust the data for that. So the actual number of appeals is a little bit higher, but we didn't want it to look like we had done a tremendous number of office conferences when it was in fact one where we consolidated all of the matters into one outcome. So just wanted to, trying to be very transparent with our data here. Okay, next slide, please. So now this is showing the citations that we issued under our general authority under 4314. So this is not including the higher fines. So you'll notice that we issued 895 citations. 351 of those were with no fine included in it. Then you can see the fines assessed and then the fines collected. And it's very difficult to do, and I would caution people from drawing a direct connection between the fines assessed and the fines collected, because again, that's going to spread out over fiscal years. So this is the money that was collected in the fiscal year. It's not necessarily linked directly to the fines that were assessed during the fiscal year. Hopefully that makes sense to everybody. Next slide, please. So then this talks about the higher fine authority. So we've had the authority for a little over a year and a half now. So you'll notice in that first fiscal year, we did not issue a lot. However, in 22-23, then you'll see that we are starting to use the tool a little bit more. You will see that the fines assessed is 1.4+ million, and the fines collected is 70,000. And here I'm going to just like remind everybody of what I said at the very beginning, where we really need to keep our conversation to the data, because there are a tremendous number of items that are pending before, at the Office of Administrative Hearings and or at the AG's office. And it is extremely important that we be mindful of the potential for ex parte communication and take all actions that we can to prevent that from occurring. Next slide, please. So this slide kind of shows where these fines are being issued, where we have the higher fine authority. So you will notice from this slide that we are not going to the maximum fine authority for all of these fines that are being issued under that new authority. In fact, the majority of the citations that are issued under the new authority fall between $5,000 and $10,000 range. You'll do 40 of them fall within that, another 12 between the 10 and 15. And again, we want to go back and be mindful of the authorities that are granted, the conditions that must be met. We're also taking into account license history, the number of violations, and everything else. So there is not a set fine schedule. We are looking at the totality of the circumstances, license history of the corporation. So, but wanted to highlight that the vast majority are not resulting in that maximum fine amount at the front end. Next slide, please. So going back to our more traditional citations, this shows the number of citations completed, those that were contested in an office conference, and those that were contested at the Attorney General's office. And again, they can cross over fiscal years. Next slide, please. And then this is for that higher fine amount. And so as things work their way through the process, you'll see. So you'll notice on here that we've only completed 8 citations that were issued under that new fine authority. So this really does underscore the number of those that are under appeal in some fashion. Next slide, please. So this eye chart talks about the top violations for pharmacies that were issued a citation and a fine. And this information that we're providing, where we're talking about top violations and everything, right? You've heard it from the AG's office, you've heard it from Julie, you hear it again from me. There's a spectrum. And so there is no violation, there is no rule that says a failure to notify the board of a change in PIC 1 results in the issuance of a citation, because it might not, right? But there's not a predetermined fine amount for that kind of violation. So just wanting to highlight that. So this kind of information that we have on this slide is a really good example of the types of information that we are then going to turn into education to our licensees, sharing this information on the top types of violations, putting that into our newsletter, putting it in the public space as much as possible. Next slide, please. So this is the top 10 violations for pharmacists. Now, I want to highlight that when we talk about our different fine authorities, the authority to issue a higher fine does not extend to individuals. It's for a very distinct population of community chain pharmacies. So this data here is only going to be those that are issued under the 4314. Medication errors continue to be one of the most frequent violations, followed by unprofessional conduct. And unprofessional conduct can have a large spectrum. There's lots of different things that fall under our 4301 code. Next slide, please. So pharmacy technicians, these are the top violations. And I want to highlight that, again, you can't really compare the data itself, but a citation may include more than one violation. Right, so what this encompasses are the violations themselves that resulted in the issuance of a citation, not a citation, if that makes sense, right? So a single citation could include conviction of a crime and administering drugs and alcohol. It's a single citation, but it encompasses two different violations. So the data reflects the number of violations that resulted in the citation. And you'll notice that generally technicians by law don't have autonomy, they don't have authority to do things. So you'll notice that the violations that are here really are reflective of criminal convictions and those kinds of activities that a pharmacist is not going to have direct supervision and control over, if that makes sense. Next slide, please. So similar to Julie's slide specific to duty to consult, this is again highlighting duties, failure to provide patient consultation as required by the law. So you'll see that the number is trending slightly down. Wouldn't put too much, into that language at this point, because you'll notice this is the authority specific under 4314. So the board's general citation and fine authority. So this is the data as it reflects for citations issued under that authority. The average fine amount for a pharmacist is $844. The average fine amount for a pharmacy is about $3,462. Next slide, please. So then this shows the number of citations that we've issued for violations of failure to provide patient consultation under the higher fine authority. So you'll notice that we are starting to use these violations, the higher fine amounts for where conditions are appropriate as a way to try to secure compliance, right? And so the average fine amount for a failure to provide patient consultation, and Julie talked about all of the different elements of that in her presentation, the average fine amount is about $7,500. Some are higher, some are lower, right? It's about what that whole story is, what are the mitigating factors, the factors in aggravation. Next slide, please. So this is kind of the last slide, and because it's relatively new authority, we thought it would be helpful for the committee to kind of understand where we are seeing or where we are using the higher fine amount tools. So I talked a little bit at the beginning that 4317.5A gives the board the authority to issue a fine of up to $100,000. That is typically for repeat violations that are occurring in a community chain pharmacy under the same ownership. And then 4317.5B, that is authority that gives the board the authority to issue a fine of up to $150,000 $50,000, and that is really linked to policies and procedures. So I'm not an attorney, and I'm way oversimplifying, but I'm trying to give you like kind of basic context of the differences between the two. So when we look at the common violations, you'll notice that some of these dollar amounts are a little bit weird. So what I want to explain is similar to the technicians, right? These are the violations that were issued in a citation, but it could be more than one. So there could be a citation where they failed to notify the board of a change of PIC, and they also failed to notify the board of an interim. So you will notice that some of these dollar figures are less than $5,000. And that's because, one, we're showing the average for that violation, but also, if you remember back to the beginning of the presentation where I talked about our general fine authority is $5,000 per investigation. So now under 4317.5, we are not limited by that 5,000, but that doesn't mean we're going to go to 100,000 for every single one that we find. And this data really kind of supports that we are not going to that highest fine amount in everything that we do. What will be interesting to see, at the staff level, is as we continue, you saw that a significant number of them are under appeal. So it will be the appeals and the administrative law judge decisions, and what you all do as the policymaker will, in your decision making of that, will then continue to provide feedback back to staff through your actions that will then help us to adjust how we are doing things based on what you all in your role determine is appropriate through your adoption or non-adoption of different things. So that is it for the little presentation. So thank you very much.
Thank you. Members, do you have any questions or comments for Ann? Okay, we'll move on to public comment. And as a reminder, for public comment, this is not a question and answer session, but rather an opportunity to provide comments on the presentation. Let's begin with public comment here in Sacramento. Any public comment? Okay, seeing none, let's move to public comment via WebEx.
And this is the moderator, and we've opened up WebEx's Q&A feature to facilitate public comment. If you'd like to make a comment on the presentation, instructions are on the screen. You may raise your hand by clicking on the hand icon. You may look for the question mark icon, typically in the lower right of your WebEx screen or behind the 3-dot other options if you're on a mobile device, and you can type the word comment into that text box and click send, or our call-in users can press *3 to raise their hand. Each speaker will have 3 minutes to speak with a 10-second warning. Are there any comments? And I do not see any requests for comment. Shall I close the public comment feature?
Please do, thank you.
You're welcome.
Thank you, Ann, for your excellent presentation and for summarizing the data that we often don't see about citations and fines. So this annual presentation is very helpful. Thank you. Moving on, agenda item 7, presentation and discussion on quality assurance reports received pursuant to California Code of Regulations 1711F related to the use of automated drug delivery systems. As detailed in the meeting materials, the board is required to submit a report to the legislature on the regulation of automated drug delivery systems as a part of its upcoming sunset evaluation process. To ensure we have time for discussion and input in advance of the report deadline, I appreciate staff presenting this preliminary report and providing us an opportunity to provide feedback to ensure we have all the data needed and recommendations ready for the legislature. I welcome Supervising Inspector Janice Dang. Thank you for being here, who will be providing us our presentation. Janice, up to you. Is your microphone, turn on the microphone.
Okay, can you hear me? Okay, good morning. My name is Janice Dang. I'm a supervising inspector with the board on the compliance team, and I also oversee the 2 ADDS inspectors who are specifically assigned to do majority of the ADDS pre-license inspections. So today I'm going to provide a presentation on a review of the ADDS quality assurance programs. And just as a refresher, ADDS stands for Automated Drug Delivery Systems. There's 2 different types of systems. There's the AUDS, which is the Automated Unit Dose System, which is primarily used for administration. And then there's the APDS, which is the Automated Patient Dispensing System, which is the type of device that dispenses directly to the patient. Next slide, please. Okay, in 2018, there were 3 different bills related to the use of ADDS requiring pharmacies to license the ADDS. Prior to that, the board's requirement was only registration of the ADDS. So now they were required to be licensed as well as required a pre-license inspection prior to the issuance of the license. So there was AB 1447, which went into effect or became operative July 1st. And these are primarily most of the ADDSs that we do license currently. They're the ADDS used for administration in skilled nursing facilities, intermediate care facilities, and doctor's office, and so forth. Okay. I keep getting a pop-up. Okay, so in AB 1447, as I mentioned, these included ADDS located adjacent to the pharmacy. Originally, when we had these ADDSs adjacent to the pharmacy, they were for refill use only. That over the years have changed. These also include a healthcare facility pursuant to Health and Safety Code 1250. So these are your acute care hospitals, your acute psychiatric hospitals, your skilled nursing facilities, your intermediate care facilities. Majority of these were licensed under the Department of Healthcare Services, and they were also required to comply with Health and Safety Code 1261.6, even though Health and Safety Code 1261.6 referenced skilled nursing, intermediate care facility, and nursing facilities. Under 4427.2, this would also apply to hospitals who are operating ADDS. A clinic pursuant to 1204 or 12041, so primary, these were your clinics licensed by the board under 4180 and 4190, your free clinics as well as your surgical clinics. The correctional clinic pursuant to 4187.1, and a correctional clinic is specifically applies to prisons that are operated under the California Department of CDC, Corrections and Rehabilitation. I'm sorry. And then there's also the APDSs, which can be located in medical offices or other locations where patients regularly receive care. Next slide, please. Okay, AB 1447 also stated that if you were a acute care hospital or a acute care psychiatric facility, that you were exempt from licensure, but you were also required to comply with all other requirements of the ADDS. So the only exemption is that they did not need to have it licensed, provided one, that they owned, operated the ADDS, that they, and the drugs contained in the ADDS was owned by the pharmacy and, let's see, yeah, and owned by the pharmacy, and that it was only used for administration. So if it went beyond the use of administration, such as drug rooms and the ADDS located in the emergency rooms, if they were used for dispensing, we did require them to be licensed because they were no longer exempt because they're going beyond the administration. And then also it addressed that if you were if you had a ADDS located inside the pharmacy where it was used to assist you in labeling, counting the prescription, then it was not required to be licensed as well. It did not have the wording similar to how it applied to hospitals and acute care psychiatric, that they had to comply with all other requirements. So the ADDS in a pharmacy generally are used to assist in the dispensing process, where it still required the pharmacist to do the final verification. Next slide, please. Okay, the other bill was AB 1218, also went into effect July 1st. It required a correctional clinic to be licensed by the board. Again, these are the clinics located in prisons operated by CDCR. It requires the ads located in the correctional clinics to be licensed by the board. So these were a little bit different. They had to be licensed first as a correctional clinic, and then they were required to be licensed. If they're operating an ADDS, they were required to license the ADDS as well. And then the third bill was AB 2037, and that one went into effect in September of 2018. And this allowed a pharmacy to operate an APDS on the premise of a covered entity. And a covered entity is usually a clinic that services 340B drugs, or it could be on the premise of a medical professional practice who is contracted to service the 340B patients. Again, these were generally the APDSs and not AUDSs. Next slide, please. Okay, in January 1st of 2022, AB 1533 was expanded the locations where the ADDSs could be located. When originally, Business and Professions Code 4427 pretty much limited either ADDS operated by pharmacies that were specific to facilities that were operated by the Department of Healthcare Service, the California Department of Public Health. And so there was a lot of other facilities that had authority, statutory authority, to have a common emergency stock of drugs at the nursing station. So this bill expanded the locations to include also other facilities that were not licensed by CDPH, but also licensed by the Department of Healthcare Services. And primarily these were the psychiatric health facilities, the crisis stabilization units, and also some of the drug rehabilitation hospitals. This also included the jails, youth detention facilities, and other correctional facilities. So originally when I mentioned that the ADDS that were required to be licensed were operated by CDCR, a lot of the jails, the detention centers for the youth were operated by the county or the city. And so this expanded the use of the ADDSs in these other locations that were not related to CDCR. Next slide, please. So when we're talking about the quality assurance program for ADDSs, we're primarily looking at 3 different code sections. The first one is Business and Professions Code 4427.7, which requires pharmacy to comply with the quality assurance requirements established in pharmacy law, which is 4125, and California Code of Regulations 1711, and shall maintain those records within the licensed pharmacy holding the ads and also be stored separate from those records. It also included the addition of CCR 1711F, which required quality assurance report records must be immediately retrievable in the pharmacy for at least 1 year from the date the record was created. The QA related to the use of the ads must be submitted to the board within 30 days of completion of the quality assurance review, and any facility with an unlicensed ADDS, so these would be your hospital your acute care hospital as well as your acute psychiatric facilities that were exempt from licensure. They were also required to report the quality assurance review to the board on an annual basis with the renewal of their facility license. And then 442, Business and Professions Code 4427.4D, where it references drugs and devices stored in the ads as being part of the pharmacy's inventory and responsibility. Drugs and devices dispensed from the ads shall be considered to be dispensed by the pharmacy. Next slide, please. To assist the licensee, the board came out with the frequently asked questions that was posted on the board's website. In 2021, the board updated the FAQs to include 4 questions related specifically to the reporting of, and to address questions related to the quality assurance reporting with the use of ADDSs. So there was question number 6, where a medication error was made and the quality assurance was completed. Do I have to report it to the board? And the answer was yes, specifically referencing California Code of Regulations 1711F. And then we gave them some examples of what would be required to be reported. Next slide. Then there was question 7, which asked, my pharmacy is located in an acute care hospital and exempt from the licensing requirements for ads. Do I have to report all quality assurance reports related to the use of ads to the board at the time of renewal, including the quality assurance reports related to near misses or errors that were caught by the nurse? And here the answer was yes, again referencing 1711. Next slide, please. The question number 8 is what information was required to be reported to the board as part of the quality assurance review? When the board did not create, and the law did not require a specific form to be submitted. It did require, though, that you submit a quality assurance review. So as a result, we listed what information we would request to be reported on the quality assurance report, which would include the date, the location of the ads license number, the pharmacy license number, and the pertinent information related to the medication error, any findings, and any recommendations. Next slide, please. And then question number 9, where do I sit my quality assurance report? The board created an email address where the licensee could either, 1, report it to the email address of adds@dca.ca.gov, or they could mail it to the board's address. If you were a pharmacy operating an unlicensed ADDS, then again, also when you're renewing your license, your pharmacy license, they can also, again, either mail it with the renewal or send copies to the email address of adds@dca.ca.gov. Next slide. Okay, so we have 3 different licensing types when it comes to ADDS. The first one is what we called, we title it ADD, which are primary all your ADDS that are licensed under 4427.3 and 4427.65. And this is the bulk of, I would say, 99% of all our ADDSs. They fall under the licensing type of ADD. So prior to the law going into effect in July 1st of 2019, in preparations of to making sure that all these ADDS that were registered are now legally licensed, we proactively went out to all the current registered ADDSs. At that time, we approached the pharmacies that were operating them, and we provided them the new form for them to complete and to start scheduling all these inspections so that by the time July 1st came, they would be licensed. So we received about 595 applications initially prior to the law going into effect in anticipation of July 1st. And then as in the fiscal year of 2019-2021, we continued getting more applications as pharmacies were understanding that they were now required to be licensed and not registered. And we still continue to get applications. A lot of the applications now that we're getting has to deal with pharmacies competing with each other. So then if I service a certain nursing home and now a competitor is now servicing them, it would require a new license for that ADDS. So specifically December, we had about 1 change of location and 2 change of ownership. So it required us to go back out and reissue and do pre-license inspections on all those ADDS. So because of changes in ownership, changes in who's operating those ADDSs, we're still continuing to get a lot of applications as a result. Applications that were withdrawn after July 1st of 2019, a lot of facilities, as I mentioned earlier, such as their psychiatric health facilities, or even the youth detention centers, they did not qualify for an ADD license. So because of that, a lot of them had to withdraw their applications. We were also getting a lot of applications from hospital pharmacies that were not required to be licensed because they were exempt from licensure. So then again, those pharmacies withdraw their applications as well. So now you know that the numbers has gone down because of better education and as to which ADDS required to be licensed. So overall, when the law went into effect, in the fiscal year of 2019-2020, we issued 1,000 and 1,200 ADDS licenses, and we continue, as I mentioned, to still license a fair amount because of change of ownership and change of locations of the pharmacies. So currently, the board has 1,052 licensed ADDSs that are classified, or they have the licensing type of ADD. Next slide, please. So the next licensing type is what we call an ADC. So these are specifically to pharmacies, again, operating ADDS that are located at a clinic or a physician's office that covers 340B drugs or the covered entities. Currently, we've only and always had just one of this type of license currently, and they are still currently licensed with us. We have not received any additional applications for this type. And again, this facility type is different from those that fall under 4427. Next slide, please. And the third type, licensing type that we have is what we call an ADE, and the E stands for the Emergency Medical Services. So this is a lot different than what is defined in 4427. The board a while back worked with the emergency medical departments throughout the state to create Business and Professions Code 4119.01. And what this allowed was for an emergency medical service to either, one, apply for a pharmacy license or to apply for a wholesale license, but they were not dispensing it to patients. What the purpose of the license was to allow them to acquire drugs and then to stock these ADDSs that were located in specific fire departments. So that, for example, if you're in LA County extends all the way up to Lancaster, Palmdale, for example. And in the past, what they were doing is driving from Lancaster, Palmdale, going all the way down to downtown LA, putting that paramedic truck out of commission for that period of driving all the way back and forth. So what this allowed them to do is they would get their own stock of drugs under a pharmacy license or wholesale license, place it into designated fire stations that have ADDSs, and they would restock these ADDSs, and then from that ADDS, when the paramedic trucks went out to an emergency and came back, they used these ADDSs to restock the paramedic trucks. So that way those paramedic trucks were not required to leave and be out of service for 3 to 4 hours. Okay, so this kind of assisted them to have their paramedic trucks available during emergencies. So again, we've only had one, and we've always still have one of this type of ADE. Next slide, please. Okay, so regarding medication errors reported, I didn't have the numbers at that time, but just keep in mind that currently that are licensed ADDS, not unlicensed. They're currently, let me back up, okay. There are currently 62 pharmacies that operate ADDSs that are licensed with the board. There's 3 drug rooms. There's 27 hospital pharmacies, and primary, these are your AP, well, their AUDS is used in emergency rooms or drug rooms to dispense to patients, and there's 41 correctional facilities that have licensed ADDSs. So if you look at the numbers of medication errors being reported, in 2021, you notice that pharmacies-wise, it was 252, but how many pharmacies of those 252 reported was only 8, where currently the board has about 62 pharmacies that are licensed, that are pharmacies that are operating licensed ADS. So again, a lot of it was underreported. In regards to hospitals, we were not getting any reports during their renewals until this year, and primary, those came from one hospital. And if you keep in mind, we have close to almost 500 hospital pharmacies, only one reported. In licensed correctional facilities, this year we had 66. It's very slowly that they're reporting. And then of those, again, there's 41 licensed correctional facilities that are operating ADDSs, and only 12 reported. Next slide, please. So medication errors, where were they located? So keep in mind the type of pharmacies that are reporting these, majority came from actually a pharmacy that was a central refill pharmacy. So we did not get any reporting of med errors related to adjacent to the pharmacy, medical offices, skilled nursing facilities. And then for correctional facilities, this year we got 63 that were located in correctional facilities. Inside the pharmacy, as I mentioned, those are primarily, there was a few community pharmacies that were reporting, but the majority came from a central fill pharmacy. So I would, especially in 2021, I would say 95% of it came from that one central refill pharmacy. And then those would be your other facilities that, such as the youth detention centers, your psychiatric health facilities, and even your hospitals that are, not unlicensed. Okay, so total in 2022 to 2023, we got 270. So it's been around between 200 and 300, but like I mentioned, it's very underreported because a lot of pharmacies are not reporting their medication errors. Next slide, please. So what type of errors are we getting? There's drugs that are related to the wrong drug being dispensed, the wrong strength, the wrong quantity, a lot with the wrong quantity, and again, a bulk of it came from the central refill pharmacy where the quantity was either off by a few tablets or actually there were some that the reports were off by a lot. So the problem with these reports that we're getting is we do not know what type of the devices they are. So if they are licensed with us, we have an idea what they are, but if they're not licensed with us, we have no idea unless we physically go out there or contact them to inquire what type of ADDS they're operating. And so the bulk of it is really with the wrong quantity, but there was a total of over this 3-year period, 829 medication errors reported. Next slide. So what are the causes of these errors? What we noticed that if it was an ADDS that was in a hospital or an ADDS in a skilled nursing facility, primary your AUDSs, they were contributed to the override transaction function. And when I spoke to my 2 ADDS inspectors, they were saying, you know, one of the problems that they're noticing is that they're not limiting which drugs they can access when they're overriding. So as a result, there is some misuse and abuse of the use of the ADDS override function. The ADS allowed the use of the same code for multiple pulls. So there were some pharmacies that in order for you to use that override, you did have to call the pharmacy and get a code to put into the ADDS, but a lot of them did not have a code. They would have a universal code, and that the nurse would use those universal codes to do the override. Storing different salts of the same drug in the same location. So again, these were the type of ADDSs or AUDSs where you're not limited to just that one unit that pops open that allows you access to only one drug of that one strain. There's still devices that they're like a pie shape, or they're a drawer with multiple drugs in there. So there's that potential for the nurse to who's operating an ADDS to remove the wrong drug. There was the ADDS allowed the same dose for the same patient to remove more than once without approval, resulting in duplicate administration. There was failure to send an alert for duplicate administration. So there were patients that got the same drug twice by 2 different nurses, and part of it was contributed to failure to document that they administered the first time too. So ADS allowed the medication pulled under the wrong patient's name or with similar names. It allowed the nurse to remove the wrong dose, not on a patient's profile. It allowed the nurse to remove the wrong quantity. And sometimes the nurse would take an extra because they know that the patient spits out the dose, so they would take 2 doses out in case the patient spit out. And then now they had an extra one, so they had to put it back into the return bin. So, and then the ads allowed the nurse to remove the drug without the order reviewed by the pharmacist. So again, part of it is we don't know what type of ADDS. If it was a licensed ADDS, we have an idea because it's listed on the application. But when it comes to the hospitals using the ADS, we could not narrow it down if it's related to a specific type of ADDS. Next slide, please. So what are the challenges that the board faces when, and as well as the facilities when they're reporting these ADDS to the board? Is one specifically, is the number one is the non-compliance with the reporting, and then the inconsistent reports of information or lack of information reported. One of the difficulties that the staff had in the office in trying to enter the data is that every pharmacy has their own different form. Every pharmacy has different information that they report. A lot of the pharmacies did not indicate what type of ADDSs they have or the location of the ADDS other than here's the error. This is what happened. So it was there was a lot of information that we did not have that would make it a lot better. So, you know, one of the things that we may want to consider is if we need to do a standardized form or, again, redo the FAQs and specify exactly what they need to report again, because we're not getting that information. Next slide, please. Okay, unable to take, well, as I mentioned, unable to determine the type and model of the ADDS causing the error. There's a misunderstanding is what type of errors are required to be submitted. And then nurses, having to train these nurses that are to notify the board when an error does occur. Next slide, please. You know, one of the comments I got back, I had my 2 inspectors contact pharmacies to say, oh, have you been reporting and can you send me copies? And they say, oh, medication errors, and even education on the pharmacy part. They say, oh, contact CDPH. They have all the facilities are required to report it to CDPH. So they don't think they're required to report it to us. That, again, if it's in a nursing facility, an intermediate care facility, or a hospital, that they're only required to report to CDPH. Next slide, please. Oh, and I forgot to mention, part of it is, and this was one that both of my inspectors were saying, that there's this gap in time for training of these nurses in these facilities, because the way the law is written, they are required to train the nurses who are using the AUDSs initially prior to the use of the ADDS, and then annually thereafter. So between that year, there's a lot of nursing turnover. Same thing with directors of nurses. There's seen changes in directors. And so as a result, there's a lot of consistency, or the nurses are not familiar with the law requires, and so again, they're not reporting it. So that's part of it. And they believe that is a big portion where it's a lack of the nurses not knowing, because the education is only required annually. Let's see. In regards to pharmacies operating ADDS inside a pharmacy, we believe that part of it is maybe a misunderstanding where, in generally, if you under 1711, medication errors, are going to patients. But what the pharmacies who are operating, like the Script Pros and the Uyamas, they don't realize if the error was contributed to the ADDS. So in other words, we get, for example, when we're following up on complaint investigations where the wrong drug was dispensed, some of these ADDSs will have like a stray tablet. And so then you have all your white tablets, and all of a sudden you have an orange tablet in there. And so the pharmacies are not realizing that if it was contributed to dispensing from the ADDS, those type, and that they gone to the patient, those are the type that are required to be reported to the board, and we're not seeing those. Next slide, please. Okay, so what recommendations, in regards to recommendations to pharmacy, we believe they need to incorporate in the training of nurses what is considered a medication error during initial and annual training, but we're thinking that they should do it more often, to work with the ADDS manufacturers to provide continuous training to the pharmacies as well to help improve their pharmacy processes, to restrict the use of the override transaction function, reassess and limit which drugs can be removed during the override transaction function, and encourage the use of ADS that limit access to only one drug and not an open matrix configuration, and then consider requiring different passcodes for transactions on override. Next slide. In regards to the board, continuous education of our licensees during our pre-license inspections of the ADDS, and one of my inspectors says, what we should do is every time, because there's a lot of same pharmacies that are getting ADDS license, that we should always provide them also a copy of the FAQ each time we go out with them, so as a constant reminder, and that these are the type of med errors related to ADDS that you need to report, to consider a Script News article regarding the reporting of ADDS and medication errors, possibly issue a subscriber alert to remind pharmacies who are operating ADDSs as well as hospitals who are operating unlicensed ADDS that they're required to submit ADDS med error reports to the board, include reporting of ADDS med errors as a topic of education during routine inspections, as well as ELIS sterile compounding renewal inspections. Because one of the things that, yes, the Board of Pharmacy, we conduct routine inspections of pharmacies, but not necessarily hospitals. So we thought that during an LSC, which has to be licensed annually, it's a nice time to remind pharmacies that if they have med errors related to ADDSs, that they are required to report them annually when they're renewing their pharmacy license. conduct random inspections of pharmacies operating ADDSs, work with CDPH to notify the board when a med error occurs related to the dispensing of the ADDSs, and then updating the community pharmacy self-assessment to address reporting of med errors related to unlicensed ADDS used in pharmacies for technology, as well as assisting in counting, packaging, and labeling. Next slide, please. And thank you. That's it.
Thank you very much, Dr. Dang. Very comprehensive and informative report, and thank you for offering some suggestions and recommendations. I believe this is a great starting point, and you can see that there's a lot of information missing that's not being reported to you, but what you reported to us shows us that we have a little bit of work to do with our licensees to get them to report with you. As this is our first opportunity to review the ADDS program, I think there's some time before our report is due to the legislature, and I'm wondering if the members would be agreeable for me to work with staff to clarify some of the points and to add some other elements that I think should be brought forward for consideration. Rather than go into detail about my specific recommendations, I think I could work with Dr. Dang and with staff offline to incorporate some of these changes or suggestions, and then bring another presentation to us at our next, or at a meeting probably in about 6 months. I think it's when it would come up for the agenda. This would still allow us time to review a report, to refine it, and to still meet the legislative deadline. We would have time to review it as a committee, and then also as a full board, and still meet the legislative deadline. So I'm, kind of like I mentioned earlier, I'm very concerned about the lack of reporting by some hospitals, especially since I come from an acute care background. It's very, shocking. Hospitals that use unlicensed ADDSs are not reporting, and because of that limited data to the board, you're not able to fully review the causes and the needs and the issues. I'd like to encourage staff to consider if there are additional means what we can do to remind licensees of the reporting requirements. You mentioned some in your recommendations, but I'm wondering if, I think we talked about this in a previous meeting, but I'm not quite sure if it was just too difficult, but I think it's time to look at it again if it's possible, to have maybe some sort of checkoff box on the renewal for annual pharmacy renewal that would remind them, just like we would remind pharmacists about CEs, that they need to either consistently report errors if they're a certain license category, and if they're unlicensed, then they have to report annually at the time of their renewal. Or there could be some other means. Those are just a few of my thoughts in general, rather than getting into the detail. But members, do you have any questions or comments for Dr. Dang on the preliminary draft report? Shows you we have a lot of information to evaluate, and I really appreciate you putting something together on such a very complex issue with so very little data. We really have a lot of education to do. Thank you, and thank you to your inspectors. Before we go on, let's go to public comment. I'm sure we'll have a few people in the public that will have some comments. Similar to in the past, this is not a question and answer period, rather an opportunity to provide comments on the presentation. Let's start with public comment here in Sacramento. Any public comment? Okay, let's move on to public comment via WebEx. Moderator?
And this is the moderator, and we've opened up the WebEx Q&A feature to facilitate public comment. If you'd like to make a comment on the presentation, you can either raise your hand by clicking on the hand icon, or you can click on a question mark icon, typically in the lower right of your WebEx screen, or behind 3-dot other options if you're on a mobile device. Type the word comment into the text box and click send. And our call-in users can press *3 to raise their hand. Each speaker will have 3 minutes to speak with a 10-second warning. Are there any comments? And we do have a raised hand. Let's see, someone logged into WebEx under the name John Gray. John, I'm going to send you a request to unmute yourself, and you'll have 3 minutes. You're unmuted.
Yes, thank you. Good morning. This is John Graham, a registered pharmacist with Kaiser Permanente. Thanks for the opportunity to provide some comments. Based on the information provided in the rulemaking package that modified Section 1711 in accordance with these requirements, the justification for establishing this requirement is really around the provision to provide a report to the legislature, as Supervising Inspector Dang mentioned. And so, because the board is gathering information to prepare a single report to the legislature, and, beyond that, there's no statutory reason to require this kind of reporting in perpetuity, we suggest that the board consider at some point in the future amending CCR 1711 to eliminate the reporting requirement after it has delivered its required report to the legislature. Thank you very much for the opportunity to provide comment.
Thank you, Dr. Gray.
And this is the moderator. I do not see any further requests for comment. Shall I close the public comment feature?
Please do. Thank you.
You're welcome.
Thank you, Dr. Dang. Again, that was an excellent presentation. I'm sure that's causing a lot of discussion out there in the community, and I look forward to bringing the issue back to the committee. Moving on to agenda item 8, discussion and consideration of policy statement related to implementation of USP Chapter 795, Pharmaceutical Compounding Non-Sterile Preparations, 797, Pharmaceutical Compounding Sterile Preparations, 800, Hazardous Drugs and Handling in Healthcare Settings, and 825, Radiopharmaceuticals Preparation, Compounding, Dispensing, and Repackaging. Members, as you may recall, and it's included in the meeting materials, November 1st, 2023, changes to USP Chapters 795 and 797 and the new USP Chapters 800 and 825 become compendial. For the past several years, as information was released on the dynamic and changing process from USP to establish new chapters and revise existing chapters, the board has released policy statements providing licensees with information on the board's policy on compounding and enforcement during the transition period. Attachment 6 is the latest policy statement that we're suggesting. This draft policy statement is for your consideration. I've reviewed the statement and believe it is appropriate. Members, I would welcome your thoughts, but I would also entertain a motion to recommend approval of the policy statement if the board believes, if the committee believes such action is appropriate.
This is Renee. I overall agree with the statement. I think maybe for clarity, perhaps putting very specific the USP chapters, general chapters that are being revised, are being added to the regulations. In the very beginning, it has it just says for several USP general chapters, and maybe just to be very specific. I don't know what the title of this would be. I know that our discussion agenda item lists all of the USP documents by number and name, but if it could be included in here, just to make sure everybody's clear, since there are a lot of USP general chapter. I mean, hopefully people who are using them are aware, but again, this is for awareness, so that would just be my suggestion.
That's a good point. I think that I can work with staff and with our attorney representation to make sure that it is specific, and then bring that specifically to the board for our for our official approval. Members, any other comments? Thank you, Renee.
I can make a motion to approve.
With
Renee.
Minor modifications?
Yep. With that?
Got a second?
I'll second that.
Okay, thank you. With a motion and second, we're ready for public comment. Let's begin with public comment with people in Sacramento location. Any public comment? Okay, moderator, we're ready for public comment for individuals participating via WebEx.
Thank you. And we've opened up the WebEx Q&A feature to facilitate public comment. If anyone would like to comment, you can either raise your hand or you can look for the question mark icon, type the word comment in the text box and click send. And each speaker will have 3 minutes. We do have a raised hand from John Gray. And John, I'm going to send you a request to unmute your microphone and you'll have 3 minutes.
Hi,
You're
good morning
unmuted.
again. Thank you. This is John Gray, registered pharmacist with Kaiser Permanente. Thanks for the opportunity to provide comments on the policy statement, draft policy statement. First, we want to thank the committee for drafting this policy statement and preparing to disseminate it well ahead of November 1st. This approach will provide the regulated public ample time to understand the board's policy and put it into practice. We would like to encourage the committee to use this policy statement to provide more definitive guidance to the regulated public on how the board intends to approach situations in which a pharmacy is in compliance with the applicable USP chapters, but does not comply with the provision of the current compounding regulations that directly conflict with USP. For example, in the board's current regulations, compounding in segregated compounding areas is limited to low-risk compounding. However, this is not the case in the new USP chapters, which do not apply this risk-based compounding restriction to compounding in an SCA. Therefore, we recommend that the committee consider adding additional guidance on this matter to the policy statement. We suggest something like the board intends to exercise enforcement discretion in cases in which a pharmacy is in compliance with the compounding chapters of USP and therefore in compliance with Business and Professions Code 4126.8, but does not comply with a directly conflicting provision in Article 4.5 and or Article 7 of Division 17 of Title 16 of the California Code of Regulations. Thanks for considering our feedback and for the opportunity to provide comments.
Thank you, Dr. Gray.
And this is the moderator, and I see no additional requests for comment. Shall I close the public comment feature?
Please do. Thank you.
You're welcome.
Members, do you have any additional comments before we go to the vote? Okay, let's vote. Renee Barker.
Yes, approve.
I heard you say yes?
Yes.
Indira Cameron Banks.
Yes.
Sung Oh.
Yes.
Jig Patel.
Yes.
And the chair votes yes, motion passes. Thank you. Item number 9, discussion and consideration of the committee's strategic plan. Make sure. Members, I welcome your thoughts on the strategic objectives. Let's see, I think I'm missing a page. What happened here? Oh, I missed a whole page. It was really important stuff, so let me go back. As indicated in the meeting materials and detailed in the committee report, the Enforcement and Compounding Committee has 9 strategic objectives. The meeting materials include updates on the objectives and highlight our efforts over the past year. I would like to suggest some additional updates to the strategic objectives in a few areas, and I'll list them. Specifically related to Objective 2.3 regarding routine pharmacy inspections at least every 4 years. I appreciate the update and think we should elaborate further. As the inspection presentation highlighted, we are making good progress toward this goal. I believe we should include the percentage of licensees that meet the established criteria for each year, and perhaps comment that staff is continuing to prioritize pharmacies that have not been inspected for over 4 years. In addition, specific to Objective 2.6 regarding inspector consistency, I think we should note that post-inspection surveys are performed as a means to provide feedback from licensees. Further, I believe management staff review cases together as a team to achieve consistency where appropriate. Lastly, specific to Objective 2.8, this is regarding education of licensees on enforcement responsibilities. I believe it is appropriate to highlight the number of FAQs and script articles that have been published to assist licensees. In addition, there are several presentations provided by the board, both in person and recorded online, to provide information on common citations and how to prepare for an inspection. Our EO also provides presentations each year to groups of pharmacy professionals regarding the work of the board and answering common compliance questions. There is also the work of the licensing committee that is improving the education and preparation of PICs that could be included in this section. Generally, I believe the objectives remain appropriate, and I don't believe changes on the strategic objectives are needed. Members, I welcome your thoughts on my suggestions to the details and your thoughts on the actual strategic objectives.
Just want to say thank the staff for their hard work. I believe for 2.9, licensing committee is looking into if there's any opportunities. But other than that, thank you for all your hard work.
This is Renee. Yeah, there's a lot of work being done here, so thank you. And it's, you know, so much progress in 1 year. I did want to add to 2.6, just thinking ahead, even from our last agenda item. I'm not sure how that would look, but just, you know, like, because there's, with the regulations changing and updating, kind of how that would look, proactive training to ensure consistency with some of the interpretation during inspections. I don't know if that will just show up as in some of these other numbers, but just as an awareness. Yeah, thank you.
Are you referring to proactive training of inspectors, or what did you mean by proactive training?
So I think in the consistent, just in as it is for consistency with the new regulations and the inspection, how some of the what will be the interpretation for some of the verbiage that we've, you know, that was written, and just what that would look like. So many different types of pharmacies and how that will apply.
Okay, I think I got a little bit of an idea about proactive information and education to licensees.
Mm-hmm.
Any other comments from board members? Okay, seeing none, I think we're ready. Oh, did I get, oh, I don't need it. I think we're ready for public comment. Do we have any public comment from people in Sacramento? Okay, seeing none, we're ready for public comment via WebEx.
And this is the moderator, and we've opened up the WebEx Q&A feature to facilitate public comment. If you have any comment or question about the strategic objectives that were presented, you may look for the question mark icon, or you may raise your hand by clicking on the hand icon, and each speaker will have 3 minutes to speak. Are there any questions or comments? And I do not see any comment requests for comment at this time. Shall I close public comment?
Please do, thank you.
You're welcome.
Since we're not recommending any changes to the specific objectives specifically and only reporting on the current objectives, there's no need for a vote. So let's move on. Discussion and consideration of enforcement statistics. The meeting materials include a summary of enforcement statistics from the last fiscal year, along with a 3-year comparison. The board initiated over 3,500 investigations, which is about a 50% increase from fiscal year 2021. In addition, the board has experienced about a 25% increase in case closed over the 3-year period. Although the types of complaint investigations vary across the various types, I do want to highlight that the overall increase of citations issued and matters referred to the AG's office. Some of the largest increases in investigations pending include probation, PRP monitoring, and criminal convictions. Members, I welcome your thoughts over these, your thoughts on the enforcement statistics. Okay, seeing none, I think we're ready for public comment. Any public comment in Sacramento? Seeing none, I think we're ready for public comment from WebEx.
And this is the moderator, and we are open for public comment on the enforcement statistics. If anyone would like to ask a question or make a comment, You can look for the question mark icon, or you may raise your hand, and our call-in users may press *3 to raise their hand. Each speaker will have 3 minutes to speak. Are there any questions or comments? And I do not see any requests to comment. Shall I close that feature?
Please do, thank you.
You're welcome.
Okay, moving on, our last item on the agenda is future meeting dates and adjournment. Before we adjourn today, I'd like to thank everyone for your time and participation. Our next meeting is currently scheduled for October 19th. This meeting will also be conducted in person, with stakeholders again having the option to participate in person or via WebEx. Please feel free to join us in Sacramento or via WebEx. The meeting information is on the board's website. Thank you all. The meeting is adjourned. And